Courts. We have 3 cases on our afternoon docket, and council should have received the order consolidating them for argument. We're going to be giving each side 30 minutes per side, and counsel for the appellant should reserve however much time you're going to use for rebuttal only once. You'll get 1 rebuttal. So our counsel for the appellees, will you be splitting your time for the argument? Yes. Okay. So you need to keep track of that yourself as to how much time is remaining for that. And thank you to everyone for being here today. We're happy to have you in this beautiful courtroom, in this beautiful courthouse on a hot day. I would just remind everyone in the courtroom, please turn off any electronic devices that you have that might receive a text or an email during the course of our arguments today, because they have a tendency to disrupt our live streaming equipment. We are live streaming on the web, and so I would remind counsel that any confidential information that you might have that you don't want to go out to the world at large, keep that in mind as you make your argument. So we're ready to proceed with I hope I'm pronouncing that right, versus Board of County Commissioners. I'm going to miss this one up too. Dimacali versus Board of County Commissioners, and Twilight Ridge versus County Commissioners. So please proceed.
May it please the court. I'm Britt Clayton, registration 15940, with the firm of Riley, Carlock, and Applewhite, representing Ms. Dimacali, the Awe family, and the Robinson family through their entity, Twilight Ridge. I'm outnumbered greatly in the courtroom today, but just imagine my hundreds of fans watching us stream online. All 3 of these cases involve interpretation of the used as a unit element in the residential classification statute, CRS 39-102-14.4a. I will begin my prepared remarks by addressing the legal issues and authorities that are common to all 3 cases, including recent conflicting decisions from different divisions of this court. I will then discuss how the facts of each case satisfy the used as a unit element properly construed as a matter of law. I welcome the court's questions on any issue at any time. In each of these cases, it is undisputed that if the 2 parcels owned by the taxpayer were instead a single parcel, the used as a unit element would be satisfied for 100% of the land under the standards of Gurman and Farney. The fundamental legal question this court has to answer is, does the used as a unit language in the statute have a different meaning, leading to a different result when there are multiple parcels rather than one? We submit the answer is no. The 2 situations are fundamentally the same and should be treated the same. First, we start with the language and structure of the statute. We see that a parcel of land and contiguous parcels under common ownership are grammatically interchangeable. They're treated the same. All the language that follows the parcel language, including the used as a unit element, is the same, and it applies to both single parcel and multi-parcel situations. Second, as the appellees have correctly noted, we must consider the constitutional requirement of uniformity, treating similarly situated taxpayers the same. Multi-parcel homeowners use their land in the very same way as single parcel homeowners, keeping other people off the land, looking at wildlife, protecting the view, walking around and recreating on your little domain. There's no substantive difference between single parcel and multi-parcel homeowners that could justify a different legislative treatment of these 2 groups on the used as a unit element. As a principle of statutory construction, we must avoid interpreting the statute to violate the uniformity clause by treating these similarly situated homeowners differently. Third, we must consider the ARL, the Assessor's Reference Library. We need to be cautious here because the ARL is not binding on the courts. The appellees seize on the word integral in the ARL to argue that the statute requires essential uses of a contiguous parcel. Nothing in the statute or the ARL supports that at all.
Excuse me, counsel.
Yes.
You've just said that the ARL is not binding on the courts. Can you please explain that?
Well, the law is clear that the ARL is not binding on courts. It may be persuasive to the extent that it is consistent with the statutory scheme. And the case law shows, if you look at the facts where deference to the ARL has generally occurred, they are technical appraisal type of issues where the training and experience of these appraisers and assessors comes into play, valuation methodologies, for example. But this court and the Supreme Court have not hesitated to completely put the ARL aside and do the job of statutory construction. To the extent the ARL is inconsistent, they'll revise it. That's what they do.
Could we stay on that point for a moment, Mr. Clayton?
Yes.
A couple of things. The two cases on which you rely for your interpretation primarily on this point are Farney and Gurman, or Geierman, however it's pronounced.
Right.
Now, in both of those cases, as I recall, this court, divisions of this court affirmed the BAA, acknowledging the deference that we owe to the BAA's determination. And as I understand it, you are now asking us to reverse the BAA based on two cases that simply deferred to its decision on this particular issue. Is there a little bit of a tension here?
Respectfully, I would say that, let me focus on Gurman first, and then we'll talk
Okay,
about Farney,
sure.
because it's a much more abbreviated discussion. In Gurman, the assessor, down at the county level, the assessor said of this 36-acre parcel, only 2.75 acres is used with the residents, the rest is vacant land. The BAA reversed and said, no, it's all residential. On appeal to this court, the issue then was, is there sufficient evidence to support that conclusion?
Excuse me, but wasn't the primary issue in Gurman whether there was any limit on the amount of acreage that could be entitled to residential classification?
That is a legal proposition that comes out of it, yes.
Indeed.
The assessor thought he could determine how much is really needed for residential.
And then, as I remember the case, the secondary issue was, then what, now that we've got a residence here and we say there's no limit on the acreage, is there any reason to treat that whole parcel differently? And deferring to the BAA, the division said no. Is that a
Correct.
fair
And
interpretation?
the reason is because the evidence presented before the BAA, which was uncontradicted, was that the taxpayer used the property to, quote, keep other people off of it and look at the wildlife that's out there. This court held that is sufficient as a matter of law to classify the entire parcel as residential.
And respectfully, that's where I disagree with you. I don't think they said that is sufficient as a matter of law. They said we defer to the BAA in this circumstance, that was okay. Now, the same BAA, different people, but the same agency, is saying that's not sufficient in a multi-parcel case.
Yes, which is a question of law, not a question of fact or appraisal methodology to which the BAA or the ARL are entitled to any deference. Let me put it this way. If it's sufficient for the Gurman family to get residential classification just by keeping other people off the land and looking at the wildlife, how could it not be sufficient for other taxpayers presenting the same use? Now, we've got a bridge from the single parcel context to the multi-parcel context, I acknowledge that. But just on the single parcel context, I would submit, Your Honor, if other taxpayers come along later and establish the same facts as Gurman, a principled legal analysis requires that they receive the same treatment.
So just to follow up on this point, you read Gurman as not holding simply that the evidence supported the BAA's finding in that case. You read it as saying the evidence mandated such a finding. It would not permit any other finding.
That's what sufficiency, when a court decides as a matter of law what is sufficient to establish an element, Yes, and it is established undisputedly in another case, it's sufficient. Now, I don't mean to glom onto here, possible factual disputes, right? But let's assume for the sake of discussion, you have taxpayers who actually were making the same uses, the Gierman family and the Smith family, with a single parcel. I don't believe that the BAA or an assessor could say, yeah, the Smiths, it's not good enough for them. In this county, we have a higher standard. That's what's happened here. These administrative personnel have taken it upon themselves to decide what a higher standard should be in the multi-parcel context. And again, we'll bridge to that momentarily. But it is our position, yes, that another taxpayer with the Gierman facts is entitled, as a matter of law, to the same treatment.
Well, here's another problem that's going to be quite annoying for members of the public and the BAA and everyone else. And that is that one division of the Court of Appeals is not bound by the decision of another division of the Court of Appeals. And so we have to be persuaded that whatever other division was, got the law right. And so that's one place where I would like help.
I will turn to that. I'll skip a few pages in my outline. So the two recent cases that are in conflict are Rust versus Summit County and Hogan versus Summit County.
Well, and also, should we adopt Gierman, for that matter?
All right, maybe that was where you wanted to go to begin with. I think that stare decisis is a valuable and important doctrine. And I understand that the law, even with strong stare decisis, our legal system allows for the evolution and correction of errors. But we have a nice, consistent body of law evolving in the single parcel context, from Gierman to Farney to Fifield, and it works. And simply extending it, respecting it within the single parcel context as the law of this state. And the General Assembly has had years to change it if they didn't like it. They thought it was a misinterpretation of the statute. So I would urge this court to follow stare decisis with respect to Gierman, Farney, and Fifield.
But does stare decisis require us to extend a previous holding? You just admitted it would be an extension from a single parcel case to a multi-parcel case.
It does.
What does stare decisis have to do with whether we should extend the holdings in these other cases?
Well, I was responding to Judge Terry's
Okay,
question
fine.
about
That's fair.
should we follow Gierman? I would say yes because of stare decisis, but the leap to multi-parcel brings us to the Rust and the Hogan cases.
But before you leave that, have you ever seen any authority from this court or our Supreme Court which says that one division of another court should consider stare decisis in deciding whether to disagree with another division? Because I haven't, but maybe you have.
I can't give you a citation.
Okay, thank you.
Yeah, I'm just operating from 32 years of the sense of tradition, judicial restraint, stare decisis that is infused throughout all of our state and federal courts.
Thank you.
So if we assume that Gierman and Farney and Fifield would be followed, then the question is, should they be extended to the multi-parcel setting, which brings us to Hogan and Rust. Division 5's opinion in Hogan validates the key elements of all the arguments we've been making in these cases. Hogan holds that the structure and language of the statute demonstrate that the used as a unit element has the same construction in multi-parcel and single parcel cases. Accordingly, the construction of the statute in Gierman and Farney also applies in the multi-parcel context. It's erroneous to interpret the word integral in the ARL to impose a necessary or essential requirement in the statute because it's not permissible to add words of limitation to a statute.
Excuse me, in this particular case, didn't witnesses for both sides, Mr. Settle and Mr. Sessions, I believe the assessor, testify that used as a unit required integral use and that was more than mere incidental use when we're talking about that used as a unit requirement?
The assessor did. Mr. Settle of the DPT did not.
He did not.
He did not. Mr. Settle of the DPT testified that the DPT is the author of the ARL, and he's speaking as a designate to the head of the division. Their intent in this document is that integral is simply a synonym for used as a unit. It is not their intent that it connotes necessary or essential.
And with that, I think, I sort of get that. Integral doesn't mean necessary or essential, but do you agree that used as a unit contemplates integral use? Because otherwise, you wouldn't have to say used as a unit. You could simply say used with.
Well, I don't want to be difficult, but I'm hesitant to adopt any use of the word integral because of the way it's been co-opted. It's like, well, he agreed that, it's got to be integral. I would say the definition of what the statute requires, to expand on it a little bit, is contained in Gurman and Farney and Fifield, not the ARL.
But what about in Hogan? Hogan said that the use of integral is consistent with the statute and therefore deferred to that use.
What Hogan said, and this harkens back to the Fifield opinion, is nothing in the ARL is inconsistent with what this court has interpreted the statute to mean. Some people want to interpret the ARL to be inconsistent with these cases, but I would be comfortable with one exception about the assessor discretion. I've quarreled with the ARL about that. But on this whole point of what does the used as a unit element require, there's nothing in the ARL that compels a different result than we're suggesting. And if the language of the statute and longstanding case law lead us to a certain conclusion, as Hogan reached, there's nothing in the ARL that should stand in our way. It just should not. They're not the judges.
Okay, could we stick with the ARL just for a moment now?
Of course.
You recall that mandates a four-part inquiry, or suggests a four-part inquiry for assessors to use in these multi-parcel situations.
Yes.
Now, in your view, is that still a valid model for assessors to use, or you're not saying we should disregard that four-part inquiry?
I'm saying it is the tail wagging the dog. When this court and the divisions and maybe the Supreme Court settles the conflicts, and when the courts say what the law is, they will modify the ARL. For the courts to be saying, well, is the ARL a fair statement of the law, is a question I am hesitant to answer. It's not their job. They're trying to paraphrase the law. They're just not judges. So I'm not comfortable saying that this court should write an opinion saying used as a unit means anything lifted from the ARL. That's their interpretation.
So you may have just answered my question, but let me make sure that I understand then. And I'm quoting from your brief that use of undeveloped land in any manner to enhance the use or enjoyment of the residents, including merely keeping other people off the land, satisfies the used as a unit requirement of the statute. I have a little problem with this because the fourth of the four ARL inquiries also goes to this enjoyment of the property. And it's my memory that Mr. Settle was talking very specifically about a broad definition of that fourth element, looking at how people enjoy their properties.
Use and enjoyment for non-commercial purposes.
Indeed.
I would say that we see very much eye to eye with Mr. Settle on that element of the DPT's interpretation of the statute, in that it's expansive. But the reason I say that is not because I want anybody to defer to the ARL, but Gurman and Farney teach that.
Okay, but then can we ignore this second of the four inquiries, namely the used as a unit inquiry, if all we need is to get to the fourth one, which talks about enjoyment of the property? As I read your brief, that's a done deal. The minute somebody says, well, I enjoy that property, I like to look at the animals or whatever, case over.
Well, there are exceptions to that if there's a commercial use on the property. You know, if the parcel's fenced off and leased, to graze horses or something, where you have true mixed uses. But that brings us to Farney, which we haven't discussed yet, where the court affirmed the BAA's classification of 100% of a 360 acre, it was a multi-hundred acre parcel in Farney, as all residential. Why? Because there was a residential use and no non-residential use. So yes, it is for the vast majority of the taxpayers who would come forward. You think about it, the single parcel setting, 99.9% of taxpayers don't have a commercial or agricultural use. It's just a big residential parcel, and that doesn't bother anybody. But when it gets divided in two or assembled in two parts, now it's a whole completely different story. Now we're worried about people getting residential classification when all they're doing is just looking at it.
So,
But that's what Farney and Gierman say is okay in the single parcel. Just translate it to multi-parcel. That should not present a textual problem. It doesn't violate any case law principle. It doesn't violate a constitutional principle. They've just planted this seed that somehow it has to be more than that. It has to be active and can't be passive, and has to be tangible, and we have to be able to see it when we go out there. They're just making up all of these requirements that were repudiated in Gierman and Farney. Now they're just having another run at it in the multi-parcel situation.
Well, I have another piece that I'd like to talk with you about, and I'm going to ask your learned opponents about this as well. The county's testimony, the assessor's testimony in this case indicates that they were using an interpretation of the word integral that required fencing, indicating contiguity, or auxiliary structures on the property, the subject property,
Right.
or road crossings, or animals, primarily horses, on the subject property. Two questions. Is that a correct, legally correct interpretation of integral? And if it's not, can we tell how that affected the outcome of the proceedings?
As to the first part, integral is not a term we need to interpret. Integral is a term in the ARL. What they're doing is like trying to write a literary dissertation on the cliff notes for Moby Dick instead of the statute itself. They're quibbling about what does the ARL mean about integral when the statute doesn't use that word.
Right, but the case law is clear that we should give deference to the agency as long as their interpretation is reasonable. So don't you have to convince us their interpretation is not reasonable?
It's whether it's consistent with or contrary to law.
Right, so it's not worthless. We're supposed to defer to it as long as it's reasonably construing the statute. So I don't think we can just ignore it because it's not in the statute, the word integral, for example.
Well, I'm not talking about the agency's interpretation. I'm talking about the county assessor's interpretation.
And to the second part of the question, Judge Terry, these additional requirements are just made up out of whole cloth to make it more difficult for taxpayers in their county to get residential classification.
Well, can we tell how, if at all, this interpretation affected the decisions in these three cases?
The BAA in these cases and the many others of a similar ilk that we've cited to you, all these opinions read like stuck record, same language over and over again. They don't give findings of historical fact and then a statement of the legal standard and then apply the facts to the law. So it's this mashup of we're convinced that it's not used as a unit in conjunction with the residential improvements. So it starts off like it's sounding like a factual finding, but then they just parrot the language of the statute. And we know that the assessor has interpreted that language to exclude, intangible uses. So there are not any good findings of fact in any of these cases. They are crafted to make it sound like it's factual, but what it's really doing is just buying into the assessor's interpretation of the statute, and even worse, the assessor's interpretation of the ARL, which is just, it's like meta-interpretation, interpretation of the interpretation. We should be going right back directly to the statute itself.
And what are we doing then with the statutory language that says used as a unit? Explain to me why your interpretation doesn't simply read the as a unit part out of the statute.
Hearkening back, just for purposes of analogy, to the single parcel context. The Gurmans didn't use their property as two pieces. They used it as one. It was just their parcel, their land, their home. It wasn't pieces. It was just one thing. Now, you have two parcels, okay, now we have two legal parcels, but if it's used in exactly the same way, isn't it still used as a unit in a way that Gurman would find satisfactory? And again, assuming no non-residential uses, assuming no goofy fact patterns, right? I mean, I can't deal with the 1 in a million, fact pattern that throws, everybody for a loop. But 99.9% of people that have single parcels or multi-parcels use them as a unit. It's not a bad thing.
Which they can do by looking at animals on the other property or enjoying the view?
Exactly. That's what Gurman says. That's all that is required.
Can I return to your answer to Judge Terry's question about whether we can tell from the board's order here whether it relied on the county assessor's testimony as to what the law means? I mean, I think you suggested earlier you agreed with at least most of what the Hogan decision said. And Hogan had a problem with the board's analysis because in there the board explicitly adopted the assessor's interpretation, which the division found erroneous. Here, did the board explicitly adopt the assessor's interpretation, or is it different from Hogan?
No, and pardon me for being cynical, but in its first opinions on these issues in the cases from Summit County, the board was very clear, we think the assessor is right. And then somebody realized, well, that's kind of a ticket to reversal, on legal grounds. Why don't we start crafting our opinion so it's a matter of credibility and we're not persuaded that there's used as a unit in conjunction with the residential improvements. So now it's this mashup that you see in these La Plata County cases and Eagle and other counties that are coming before this court. It is obscure, and I believe intentionally obscure. Now, Hogan thought that a remand was necessary, the Hogan division thought a remand was necessary to have the board apply the right legal standard and redetermine the issue. We believe the undisputed facts in Hogan, which I don't want to argue, but certainly the undisputed facts in these three cases, undisputed or indisputable, require residential classification. There'd be no purpose to be served by remanding to the BAA for a determination. Suppose these were single parcel cases, right? Would you conceivably remand to determine whether they satisfy the Gurman standard? No. You just say, well, there's no non-residential use. They get some, buffering enjoyment out of it. That's all it takes, right? So now in the multi-parcel case, why would we remand? I'd like to hear this from my worthy opponents. If Hogan is a correct statement of the law, if it's a correct statement, how could the BAA legitimately, in conformance with the law, deny residential classification? It may seem like, well, that's a big stretch. You're saying, well, they have to find residential classification here. But, in Gurman, it was such a low threshold. Farney says if there's no non-residential use, you classify 100% of the land. If that's the law applicable to this situation, remand is only asking for another appeal unnecessarily. We ask this court to decide as a matter of law the kernels of facts in each of these cases not only permit, but because they are legally sufficient and these kernels are indisputable, residential classification is required as a matter of law. I'll reserve my few remaining minutes if I may.
Thank you, counsel.
May it please the court, my name is Kathleen Lyon, and I am an assistant county attorney for the La Plata County Attorney's Office. My registration number is 35988, and I am here today on behalf of the La Plata County appellees. I will be dividing my time today with Katie Allison from the Attorney General's Office, who is here on behalf of the Board of Assessment Appeals in these cases.
And before we start the clock, I just want to mention that I would like to hear a response to the question that I posed to your opponent, which is, given the interpretation by the assessor with these elements that don't appear either in what's the ARL, that's it, either in the ARL or in the other documentation, how that, if at all, affected the outcome before the BAA. Okay?
And may I defer answering your question, or would you like to hear the answer? to begin with?
Whenever you want to get
Okay.
to it, I just want to hear
Thank
how
you.
that comes out.
So with regard to uniformity, which I know is something opposing counsel mentioned, in the context of classification of property for tax purposes, the state constitution does require that each class of property be taxed uniformly. Such uniformity can only be maintained on a statewide basis by the use of well-defined criteria, such as that is set forth in the ARL. And the assessors can only logically and reasonably determine what property belongs in each class for classification purposes based on objective, verifiable evidence that's based on facts. Thus, it's obvious that trying to rely on one's own personal perceptions about their view or their subjective feelings, the peace and serenity that they say they gain from owning property, cannot provide the evidence that's necessary to classify property uniformly.
Could we stop right there, not to take you off the track, but in the Twilight case, as I recall, the board made a finding of fact that the property owners didn't buy the adjacent parcel for the view because the view was better the other direction. They credited the testimony of the assessor, who liked the golf course view better than the mountain view. Is that, in fact, the sort of a finding of fact based on credibility to which we have to defer?
To the extent that there is any argument about a view, which we believe is not an acceptable use as a unit, we believe that it must be based on actual objective facts. In the Twilight case, for example, part of the rationale from the assessor was based on the actual location of the decks on the property and verifiable facts and information that helped establish the view. It was not merely the personal perception of the taxpayer, but it was based on observable, verifiable facts based on the orientation of the property, the location of the decks, location of buildable lots, according to the plat on the subject property. So those sorts of objective facts were something that should be deferred to if a view is at all to be accepted as an instance. While the appellants have asserted in these cases that their purported activities or uses on these lots were not implausible, these blanket statements do not satisfy the requirement that they showed that it was more likely than not that they used the properties as a unit in conjunction with required residential improvements. It would also amount to an impermissible burden shifting and making the counties essentially have to discount someone's own subjective opinions. Instead, both the Rust and the Hogan courts, as well as other applicable law that we have set forth in our briefs, establish that the appellants must show that there is an integral use of the vacant lot in conjunction with required improvements. In each of these cases, not only did the taxpayers fail to establish an integral use, but they failed to convince and persuade the BAA that they actually used the lots at all as claimed. I would say, with respect to Judge Terry's question, the assessor did note in his testimony, although in speaking about fencing or roads, that those are the types of information that they look for as far as objective evidence and facts of trying to determine that the parcels function as a unit. He recognized that under the current Fifield court holding and the guidance contained in the ARL that no such improvements were required, and instead focused on the unverified and unverifiable testimony that was set forth by the appellants in each of the cases regarding their purported views or their love for the land. In the Dimacali case, for example, the appellants claimed that the property, part of the reason for holding the property was to preserve it for her grandchildren to use. However, based on contradictory facts, it was shown that the property had been listed for sale in 2013 and that other things and boundary adjustments had occurred, which was at least circumstantial evidence to contradict her purported personal statement about wanting to preserve the property.
Ms. Lyon?
Yes.
Responding or returning back to your answer to Judge Terry's question about what the board found important in, for example, a county assessor's testimony, I think, correct me if I'm wrong, but I think in all three cases in the board's orders, the board specifically noted that the assessor had acknowledged that residential improvements were not necessary on the contiguous parcel, so that he wasn't basing his decision on such a requirement. He made his decision based on the other facts.
Correct.
Okay.
Yes, he acknowledged, and that was noted by them. I would say also with respect to the idea that these are somehow predetermined decisions, there is a case in front of a different division of this court in a few weeks from La Plata County entitled the Martin Trust case, in which the BAA actually determined that they believed that the views that the Martins espoused would be affected by a building or something else occurring on the vacant lot. And although they talked about the de minimis activities, they credited that and found that, at least with respect to the use as a unit element, that had been met in that case. There are cases from other counties as well. We're aware of cases from Eagle, Summit, Park, and Route cases where the Board of Assessment Appeals in various parts found in favor of the appellants based on their purported uses.
So are you basically telling us the board is reaching inconsistent decisions in all these cases?
No, I believe in these cases the board is trying to determine based on what they believe are the facts, whether or not the facts they believe support the idea that if you, they have, at this point, we believe erroneously determined, as we will have cross-appealed in the Martin case, that a view can satisfy the use as a unit requirement. However, based on that opinion, which led them to make the holding they did in the Martin case, they have found similar view corridors in other cases based on what they believe are the objective facts. So I do not believe that they have erroneously based their determination on any information that may have been provided about what the county's opinion is. Instead, they're looking at the objective facts that are actually presented to them in these matters.
So you and Ms. Allen will be at separate tables in 2 weeks.
Yes, or one of her colleagues.
One of the things that concerns me about the AW case is it sounds like some of the testimony was contrary, that was given by the assessors, was contrary to the photographic evidence that there had been trees planted and so forth, and
I think the
it
testimony in those...
looked like what the assessors were relying on was the fact that there weren't structures
I believe...
or horses.
Well, no, I believe because so what was stated during cross-examination by Mr. Ah was that the trees most of the trees had died from attrition or they had been cut down, and that the...
But he did say that he was using them as a fence, at least.
He said that he had thought about rebuilding them as a fence, but he hadn't really done much work on those. He also, as far as the fire pit and the rock formations that were discussed, even though the assessor and one of their appraisers inspected the property, they did not find any evidence of that. Mr. Ah admitted that the fire pit had not been used during the relevant time, and there was no demonstrative evidence to support the other claims of use, which the assessors did not see during their views. So I think the fact that he spoke about the trees themselves that had been used supposedly as a windbreak, and now he was thinking about using those as a fence, based on the BAA's authority to weigh the credibility of the testimony as they heard it, since they were able to hear and examine the witnesses, that ability to examine the weight and the testimony, they had the ability to determine even uncontroverted evidence as to whether or not they were persuaded that the property was actually used as was claimed. And they found that those, based on their right to examine the credibility and the evidence, that they did not find that those uses had occurred, and since those findings we believe are supported in the record, they should not be disturbed on appeal.
Ms. Lyon, I think that your opponent was focusing on the notion that a single parcel case should be treated the same as a contiguous parcel case. And as far as I understand your briefs, you disagree with that proposition.
Correct.
And if that's so, why? Why should they be treated differently?
I think, first, I believe the Rust Court correctly discusses or correctly lays out the fundamental difference. There is a fundamental difference between a single parcel case and a multi-parcel case. When you have a single parcel case, as the Rust Court correctly noted, there is an inherent unified character to the parcel. And because a single parcel must contain a residential dwelling unit, as set forth in other cases before that have been decided by this court, that inherent unified character in of itself is evidence of integral use. So provided that there are not non-residential uses, commercial, industrial, agricultural uses, the integral nature of the parcel exists on its face. However, in multi-parcel cases, that inherent nature is lacking. The assessors have a statutory duty to assess each parcel of real property. They do not assess assemblages of property. And thus, in order to satisfy the requirement, the used as a unit requirement, that integral use is required in both single parcel and multi-parcel cases. But how you establish that to show that the integral use actually exists is different, since it's not inherently part of a multi-parcel case. You must provide actual evidence that the integral use exists. With respect to the Geierman and Farney cases, respectfully, we believe and disagree with opposing counsel that it's a gross overgeneralization and a mischaracterization of what Geierman and Farney hold to suggest that as a matter of law, a passive use, if that's what you want to call it, of keeping people off property satisfies the requirement even in a single parcel case. And respectfully, we believe that the Hogan Court was erroneous in adopting that overgeneralization.
Well, given the findings that were made in some of the multiple parcel cases, why would we discern from that uses such as skiing and walking dogs and playing, et cetera, on the subject parcel is insufficient for used as a unit?
We believe that they're insufficient no matter whether it's a single parcel or a multiple parcel. In the Geierman and Farney cases, we do not believe that they actually stand for the proposition that a passive use satisfies it. Instead, as a judge...
Well, why is that passive use if you're using it for skiing, for example? Ski
I think
jump
as the Rust Court correctly noted, it has to be more, to be integral, it needs to be more than an occasional use. And so in the instance where there is no verifiable data, in some cases 2 or 3 years after the fact, that you may have used it once or twice during the winter, that occasional use, according to Rust, does not satisfy the requirement of integral use. It needs to be a regular or inherent use to show that the parcels function together. With regard to specifically Geierman and Farney, the determining factor in both of those matters was that there was a residential dwelling unit on the parcels. Indeed, the Farney case was what was at issue was whether or not the structure that existed on the parcel should be deemed to be a residential dwelling unit in order to allow for residential classification, or if instead it was merely a shed and a minor structure that allowed for vacant land classification. In both the Geierman and the Farney cases, in determining, we believe correctly, that it is correct that the amount of acreage that is entitled to residential land classification is based on what is used as a unit in conjunction with those residential improvements, so that if you were using the property for something, or the dwelling unit itself for a commercial purpose or an industrial purpose, that would qualify as a mixed use. However, because the dwelling units themselves existed, based on other provisions of the tax statutes contained in Titles 1 through 13, when a dwelling unit exists on a single parcel, in the absence of a different non-residential use, i.e. a commercial, industrial, or agricultural use, the existence of that parcel in and of itself requires that the entire parcel gain residential classification. So it is not the fact that the rest of the parcel may have been used to watch wildlife, or may have been supposedly purchased in order to gain space from the neighboring parcel. all those activities show is that there was no actual commercial or industrial use occurring on the property, and instead it was the fact that the dwelling unit itself existed that requires the residential classification based on the mixed-use statutes.
Ms. Land, did you cite the tax provisions which you just referenced anywhere in your briefs?
Yes,
Or your
in
brief?
39-103 is the discussions on mixed use. So we believe that to subscribe an interpretation to Geierman or Farney that a passive use somehow is as a matter of law is a gross overcharacterization of the holdings of the case, and it imports a distorted ruling when what was really being held was that based on the dwelling unit and lack of evidence of a commercial, industrial, or agricultural use, that there was some reason to classify the property based on a mixed use. It was the dwelling unit itself. We also believe that this supports the idea that you cannot, the passive use in and of itself is not enough to satisfy what should be deemed a use for purposes of the statute. And thus we believe that the Hogan Court is erroneous to the extent that it believes that views can satisfy that requirement. The
So, Ms.
statutory...
Lyon, I'm sorry to interrupt you. If we disagree with you and we think Hogan was correct that passive uses are also relevant, does that mean you lose all three cases?
I don't believe so. First, even as a passive use, whether it's walking your dog or parking, a view is different. A view is mere enjoyment, and the Rust Court holds that peace and serenity in and of itself, which is essentially a view, or the idea about preserving property, cannot satisfy the requirement. Based on statutory construction, the legislature has determined that the tax statutes must be strictly or narrowly construed. And the case law also sets forth that to the extent if there were any ambiguities in the statutes, they must be construed in favor of the public purpose of ensuring that there is a fair and equitable proportion of revenue paid by each taxable parcel to be able to pay for necessary government purposes. So the idea that enjoyment or pleasure of owning property could satisfy a use based on these strict construction requirements simply doesn't make sense when you look at what a use would be as far as in other contexts of property law, especially looking at things like adverse possession or implied or prescriptive easements, where you have to show an open and notorious use for a certain matter of time. The use requires that the occupancy or the use of the property be the ordinary use to which it's capable. It's illogical to assume that in the context of looking at what a use is, that something saying or telling the property owner that you enjoy looking out your window to the mountains across the way, or that you enjoy looking at nature and the trees, would somehow allow for a prescriptive easement or adverse possession to claim, and it's equally illogical here. And thus, we don't believe, based on that, that you can look at, based on the common meaning of use in the dictionary, which is to actually employ something. It is more than pleasure, it's more than mere enjoyment, that use can satisfy, that views could satisfy the requirement for use as a unit. I would say, further to answer your question, Judge Navarro, in these cases, in each of these cases, despite the purported views, there was testimony that, as I said in the Twilight case with respect to Judge Voigt's question earlier, that the decks themselves were oriented in a different direction, that the views at issue were really not the views that were being claimed. I do not believe views were at issue at all in the Dimacali case, and in the Odd case, the property owner discussed the desire to maintain the rural nature of the property, and the assessor spoke in terms that if some other use was made of the property, he did not believe that it would have a significant impact on the views. Again, we believe that the determinations, based on the contradictory testimony that was provided, the credibility and the weight of the evidence was something within the authority of the BAA to make those determinations and determine what they found to be useful and credible. So I think, based on the determinations, even if view were to somehow satisfy the requirement, based on the contradictory testimony and evidence that was presented, the views in this case, the BAA found simply they did not believe that it existed or were the uses of the actual property based on what the testimony that the appellants provided. While we've spent time speaking about what it means to integrally use the property, I would briefly say we disagree that the statute cannot be construed to say necessary or essential, just because when you look at what a unit is and the definition of integral, those are both items that are composed of either constituent parts, and that the word constituent has a plain meaning of essential and necessary. So we do believe that there is, the statute itself contemplates an interpretation based on strict construction where essential or necessary use would be allowed. However, regardless of that, both the Hogan Court and the Rust Court, in recognizing that an integral use is required, have established that it's more than the low bar that's been asserted in these cases by the appellants. Even if it isn't necessary, it still must show that it functions as an integral unit and functions entirely as a constituent part of one another. Finally, briefly, I just would like to mention the dispute or the split in the different divisions of this court in the Fifield and Sullivan cases with regard to whether or not properties are required to have residential improvements.
And you're taking a position now different from what you took before the board, is that correct?
Yes, because as the assessors are required by law to follow the guidance in the ARL. According to the Huddleston case, they are bound by the ARL. The ARL itself cites Fifield for the proposition as far as what satisfies a use, and so we were bound to that at the case. However, as the court is allowed to review the statutes on a de novo basis, we believe that the split is something that the court could consider in these matters.
Is the Board of Assessment Appeals bound by the ARL?
The Board of Assessment Appeals, they are not. I don't believe they are entitled to deference. However, because it was not an issue that was raised by the county, at least in La Plata County, because we were bound to the ARL, and so we did not raise the issue of whether improvements were needed, I don't think it was an issue that they even contemplated or considered in their rulings.
Thank you.
So the Constitution defines residential real property as a residential dwelling unit, and the land is defined by law in which it's located. If the appellant's assertion that there are no residential improvements required on essentially a vacant lot, that only a residential dwelling unit is required on one lot, the legislature could have just adopted the same language in the statute in defining residential land by stating that a residential dwelling unit was all that was required. They did not. They used the term residential improvements, which is a broader definition than a dwelling unit. It also includes other structures, fixtures, fences, or amenities. And in the Vail Associates case, a division of this court found that the authority of the Constitution, the legislature had the authority to define the types of dwelling units that were residential, and also they were authorized in their definition of residential improvements to broaden the definition of residential real properties to include those types of improvements like fences, ski lines, cable lines, as long as those amenities are pertinent to a dwelling unit. We believe that this not only supports the rationale that was set forth in the Sullivan decision, but in looking at the definition of residential improvements, again, if a dwelling unit on one unit was all that was required, it would make the definition of residential improvements itself partially superfluous because it does include many other items as far as amenities, fixtures, and water rights and those items. And that cannot have been the legislative intent, otherwise they would have just used the word dwelling unit. Thank you.
I'm going to ask the bailiff to add 5 minutes to each side's time, please.
May it please the court, my name is Katie Allison, registration number 39430. I'm with the Attorney General's office, and I'm here today representing the Board of Assessment Appeals.
Ms. Allison, before you get to the substance, for purposes of these three cases, is your position any different than that articulated by the county in its brief?
Your Honor, so far, no.
Then may I ask why the board is filing a separate brief?
Your Honor, the board is entitled to file a separate brief as an appellee in the case. These cases are very important to us. As we were filing the answer brief at the same time they were filing their answer brief, we didn't know exactly what they would be arguing. And given the magnitude of the number of cases that are coming out on this issue, the board wants to have representation at this level in these cases. And we do have some differing positions potentially in some of the cases.
But you're still basically representing the agency whose decision we are reviewing is now itself filing a brief. Is that a fair characterization of what's going
Yes, Your
on?
Honor. Just, I mean, we also represent the Industrial Claim Appeals Office and often file briefs
Do you?
in support of their decisions too.
What, following up on that line of questioning, I'm a little bit confused by the board's position because they seem to be inconsistent. I mean, from the actual board's order to what you're saying in your arguments and your briefs to us. I read the board's orders in all three cases to basically accept as the law the Fifield decision. Certainly did not contest it or purport to adopt the Sullivan decision, but yet you're taking a different position on appeal and urging us to follow Sullivan and not Fifield. So how are we supposed to reconcile these sort of conflicting positions the board is taking?
Your Honor, my reading essentially of the board's decisions in these cases and my understanding is they base their decision, and this kind of goes to some questions of the court today, they base their decisions mostly on whether they thought the claimed use was actually being used that way. They didn't go heavily into the law. They didn't say integral means necessary or essential. They didn't say we explicitly choose Fifield over Sullivan. I think they more specifically found the uses not credible. And so to the extent that the board said Fifield is more relevant than Sullivan, I think if you look at the Vail Associates case, the Vail Associates case also requires that there be a residential dwelling unit on a residential property. I think the Sullivan decision and the Vail Associates decision give us the most uniform interpretation of the law, and it's the strictest construction of the law. And I think it actually, petitioner's argument is that the single parcels should be treated the same as multi-parcels. If you take that argument, then both parcels should have a residential improvement on it.
Thank you.
I want to jump to an argument or a discussion that I think answers some of the questions that have been addressed today. So even if vacant land uses such as views and buffering and enjoyment are sufficient and they're considered uses, the uses have to be credible, they have to be actually occurring on the date of the assessment, they have to be used as a unit in conjunction with the residential improvements thereon, and they have to be more than occasional. In these cases, the uses were contradicted, and the BAA is the fact finder. In Dimacali, they claim that they were hiking all the way around the subject lot. They claim that they went up, the subject lot was here, residence was here. They claim they went up the subject lot and then back down the subject lot back to the residence. But if you look at the plat and if you listen to the assessor's testimony, there's actually a cliff right along the side, the eastern border of the subject lot.
It was a 30% grade, as I recall, and so we're supposed to assume that as a matter of law, that's not hikeable, even though the taxpayers said they did hike it.
Right, and I think what the assessor ended up sort of saying, and I think what the board agreed with, was that perhaps the homeowners were thinking they were hiking on the subject lot when really they were hiking on their 11 acres of their residential lot. Because 11 acres was a big parcel of land, and the assessor really just couldn't even figure out a way that you could have gotten down that cliff. And even if it was able, even if they could get down it, they were worried about creating a rock slide. And on the plat, it said that it was a geohazard, that whole area, and you couldn't build on it.
Well, you know, not to beat up on you on this or belabor the point, but we've got some problems here because we're supposed to now uphold these decisions from your perspective by giving deference to the board's credibility findings, which we can't set aside unless they're clearly erroneous. In my view, if the board had just come out and said, letting your grandchildren play on the property isn't enough of a use, we could address that. But to say that because our person out there on one occasion didn't see these 37 grandchildren playing on the property, I'm in Twilight Ridge now, therefore, there was no such use of the property. That's really difficult, I will say, to uphold as a not clearly erroneous finding of fact.
I don't think it's necessarily difficult to uphold a credibility determination of the board. I think that's what the court is required to do, but I understand what you're saying. I completely agree that it would be helpful to just say, you know, these vacant land uses or just merely running on the property every once in a great while is an occasional incidental use that is not sufficient. In the Awe case, we had the fire pit, and that ended up being an unfinished fire pit. It was not used as the testimony sort of went on, and it was not even really visible. It was kind of overgrown by grasses. In the Twilight case, the homeowners said that they use the lots together, they treat them as one, but if you look at the pictures, there's like a rock delineation in between the two properties, and they put them up for sale separately. They also claim that they have the view, and this has been discussed today, but the situation of the house is this direction, the subject lot is this direction. So there is potentially a view of, you can see the subject lot as you're leaving the residential house at the entrance. And then the driveway in the Twilight case, they kept claiming that they needed the subject lot because it had a driveway on it, but that driveway was a platted easement that would be there whether or not they own that subject lot.
True, but why is that not an integral use? Why is that not a necessary use of the subject property to have the driveway on it?
It's a use of the subject property, but it's not a use of the vacant lot in conjunction with the residential lot.
Why not? You can't get to the main lot without going over the subject lot.
Because it's a use that's there whether or not they own the vacant lot. It's an easement that is there whether or not they own the vacant lot. So they don't even need to own the vacant lot to have that use.
I also, correct me if I'm wrong, in Twilight Ridge, the board's order says there's a separate legal access to the residential lot that does not involve crossing the subject lot. So there was a different way to access the residential lot, didn't involve going over the subject lot, is that right?
I didn't understand exactly where that would be. It was hard to tell from the
So
testimony.
maybe the board's order is just wrong on that point? Because that's what it says. Okay, thank you.
But I wasn't, in a lot of these cases, you're not there looking at the pictures when people are pointing to them and saying, here's the access. So I was unable to determine where that was from just reading the record. In general, the petitioners have a lot to gain in these cases. Their taxes will be reduced by 1/3, and that's part of the credibility determination that the board gets to consider. And also, in these cases, I think it's important to note that these homeowners have chosen not to vacate the lot line. And of course, that's not something they're required to do, but that would be evidence that they intend to use these parcels jointly together as a unit in conjunction.
What does vacate the lot line mean?
Consolidate the two lots. They can petition to have the lots consolidated into one.
Back up 2 sentences. You just said, I think, that in assessing credibility, we're entitled to take into consideration the fact that the taxpayers will save some money if the ruling goes. Well, can we assess the credibility of the county's witnesses by taking into consideration the fact that the county will get more money?
Absolutely.
Going the other way.
There's credibility on both sides, and in fact, these cases are taking, in these cases, if the homeowners are not paying residential taxes on these properties, or vacant taxes on these properties, then the county is losing money. But I think, yeah, credibility of the witnesses is key, and it can go both ways. I also want to talk about if we don't assume that these vacant land uses are sufficient. The vacant land is defined in the statute. any lot, parcel, site, or tract upon which no buildings or fixtures other than minor structures are located. All the properties here are 100% vacant. If you look only at the parcels based on their legal description, which is how, when the assessors go out there, they're looking at the one parcel based on its legal description, there would be no basis whatsoever to classify them as anything other than vacant. There are no structures, they're in their natural state. They have cliffs, shrubbery, rocks, and tall grasses. They look no different than any other vacant lot. But we have this residential land statute, and it carves out an exception for some vacant lots. And if the three elements are met, then the vacant parcel can be classified as residential. But the use as a unit in conjunction element is obviously what we're focusing on here. Almost half of the statute is devoted to this one element. It's 15 out of 32 words in the statute. The legislature intended for all 15 of these words to have meaning, and the statute must be strictly construed. When we're looking at the big picture here, no one is telling petitioners what they can or can't do on their vacant lot. If their sole purpose of the lot is to keep someone from building a house on it, that is completely fine. But they should pay taxes on the land based on what the land is used for. Here, they use the land to keep it vacant. Taxes should be assessed accordingly. We ask that you affirm the BAA's decision.
Thank you, counsel. Rebuttal?
Thank you for the extra minutes, very much. I didn't have a chance to address Rust, but since my colleagues did, I'll seize that opportunity now. Rust was incorrectly decided for two fundamental reasons. First, Rust erroneously concludes that Fifield and Sullivan hold that the occasional use of an undeveloped subject parcel and deriving peace and serenity from the parcel are insufficient. That's paragraph 10 of Rust. Sullivan did not hold anything with respect to the multi-parcel analysis because the taxpayer didn't pursue the multi-parcel prong of the statute. Everything in Sullivan regarding the multi-parcel situation is pure dictum. See Fifield, see Hogan. The court in Fifield also did not consider, even in passing, the types of uses that would be minimally sufficient to support residential classification. The court held only that improvements are not required. So when the Rust opinion states that Fifield and Sullivan hold that occasional use and deriving peace and serenity from an undeveloped parcel are insufficient, that is not correct at all. Second, Rust erroneously concludes that a different standard applies in the multi-parcel context because the ARL reasonably imposes a, quote, additional requirement that the undeveloped parcel must be integral to the residence. There are multiple problems with that conclusion in Rust. The word integral does not appear in the statute. The DPT has no authority to create an additional statutory requirement in the ARL. The courts not even have any authority to add a requirement to the statute. The Rust opinion concludes that it's, quote, reasonable to impose a, quote, additional requirement of integral use in the multi-parcel context. We submit it is inherently unreasonable, impermissible, contrary to law to violate a canon of statutory construction by adding additional words of limitation or additional requirements to a statute. It is completely erroneous.
If integral isn't part of the analysis, does used as a unit mean anything different than just used?
No, really.
It doesn't.
It means used not in two pieces, not in two different ways.
So you're reading out some language of the statute as well, then?
No. What I'm saying is that use includes merely open space. Use includes merely looking and enjoyment and buffering. Use includes all of these things. And unless there's some other use going on the property, it extends all the way out to all of the boundaries. That's all. It is a use. And it's as a unit because there's not another use. There's only one. The family thinks of it as one and treats it as one. And there's no basis for saying something else is going on. And Gurman and Farney recognize the reality of the way real people treat their land. They don't think about this slice is different and that slice is different. They think about it from boundary to boundary. And that's what normal people do. It doesn't bother anyone in the single parcel context. In the double parcel context, all of a sudden, this is so problematic. No, we have to impose some additional requirements on it. No, now it must be integral. Well, this is just struggling for additional requirements because they've planted the seed that it's necessary. You know, both councils said integral means more than occasional. It has to be more than occasional. Where is that coming from?
Didn't your own witness say that, Mr. Settle?
No. No,
I
sir.
would direct your attention, when you have a moment, to page 53 of Mr. Settle's testimony at the hearing.
Well,
Pages 52 and 53.
if he said that more than occasional use is required, that's not in the ARL, and it's not in the statute, and he's entitled to his opinion about what the law should be, perhaps, but this court must decide what the law is, and I don't accept his testimony as the Bible. We didn't even call him, you know, in the Summit County cases, the first ones tried. It was the counties that were interpreting the ARL in these, you know, crazy ways. It's like, no, we got to get Mr. Settle in here to explain that's not even what they intend by this. But I would just assume that the ARL be put aside and this court decide de novo as the judges what the law is. Let them revise the ARL. They're turning this thing on its head completely, that this court should somehow defer to Mr. Settle's interpretation of the ARL, which is just another interpretation of the statute. So, now the Rust panel was at a disadvantage because it didn't have the benefit of Mr. Settle's testimony. But the Rust panel didn't say what integral means. What does it mean? Is it just a synonym for used as a unit? Or are they buying, you know, drinking the Kool-Aid that it means necessary and essential and non-occasional and these other things? Rust gives us no ability to extend the analysis and resolve the hundreds of future cases that are out there, you know, 26 of which are in this court. The view issue in Twilight, you know, Judge Vogt, I'm so glad you raised that. This is just a perfect example about their request to have you defer to complete nonsense. An assessor comes out and says, oh yeah, well, yeah, there'd be a 5,000 square foot house right there, 48 feet away. It would not be invisible, but don't look that way. Come on, look at this way. This is your great view out here. And the board doesn't say, oh, there's no utility to protecting the view. They just say, oh, we find the assessor very credible, right? It's not a historical finding of fact. It's just this mash, and now you're supposed to defer to their credibility thing? Well, that is complete nonsense. They do not require you to check your common sense and your human experience when you enter this building to decide these cases. That is sentencing taxpayers like this to bureaucratic torment. Can you imagine what the assessors are going to do, the excuses they will find, the harebrained nonsense that they'll get away with? Because this board, BAA, is compliant in the extreme. We have cited to you 19 opinions, including the 3 in this case, and 16 others. I urge you, please, we've provided hyperlinks. Click to those 16 other cases. Look at the findings and conclusions, just the findings and conclusions.
Are you asking us to, I'm sorry to interrupt, are you asking us to take judicial notice of these things outside the record?
They're published opinions, yes, I am. They're published opinions just like yours.
Okay, thank you.
This is a troubling situation. It's a concerning situation when this board is bending over backwards to let these assessors get away with this kind of logic. Please reverse as a matter of law. Thank you.
We thank all counsel for your arguments today and your briefing. They will help us to make our decision, and we appreciate them very much. And we thank everyone who's been here today. That concludes our arguments for this afternoon. These 3 cases will now stand submitted, and a written opinion will issue in due course. The council are excused. The court will stand in recess, subject to call.